From supplementary list, item number 1.
The matter came up yesterday, my lord.
My lord, 1, 3 are more or less identical matters, my lord.
1, 2, 3.
My lord. 2 and 3, Mr. Saraf is appearing, my lord.
Yes, yes.
My lord.
Yes, sir.
My lord. My lord, in item 2 and 3, my lord, the affidavit of opposition has been filed 2 days back. But your lordship, in fact, I could know that, my lord, yesterday your lordship was examining as to whether, when no limitation is provided under the Act, then what will be the period of limitation? If I can, my lord, I was given to
This is
understand
with regard to 56, 57, it's a provision. Whether the limitation is applicable or not. So,
well, that is the question.
One is the superintendent, the other one is commissioner. The counsel appearing for the department said that insofar as the commissioner is concerned, the proceedings decided with the commissioner, it can be within 5 years. Beyond 5 years, your jurisdiction. And in case of
assessing authority.
a provision falling under 35 or
39.
39, which refers to 35 also, they said that there is no limitation prescribed.
My lord. Well, I will answer the queries raised by lordship, my lord. My lord, first of all, section 39, if your lordship looks into it, my lord, if your lordship just takes the trouble of looking at section 39.
39 refers to 35, yes.
Now, unless and until, my lord, the notice is issued under section 35, section 39 power cannot be exercised. If I read, my lord, section 39.
Yes. Section 56 and 57 or 55, 56?
39, my lord.
39 relates to the limitation, my lord.
56 and 57.
And
yes, my lord.
One minute, senior. Dr. Ashok, 1 minute.
My lord, I'm sorry.
Section 57 provides the limitation period of 5 years, my lord. That is applicable in cases proceedings are taken up under section 55 or 56, my lord.
You say 57 prescribes limitation.
Yes.
Cases falling under section
55 and 56.
Section 55 and 56.
Yes.
So limitation not applicable according to you. Section 39 proceedings. Limitation is not applicable. Is it your case?
Yes, ma'am.
Yes, Mr. Yes, Doctor. Yes.
My lord, if your lordship just looks into take the trouble of 39, my lord.
39, yes.
My lord, each and every return in relation to any tax period furnished by any registered dealer to whom notice has been issued by the commissioner under section 35. My lord.
Yes.
So, my lord, section 39 proceedings can be taken only against a person to whom notice has been issued under section 35 by the commissioner. Now, section 35, you will also see. It speaks of certain circumstances in which a notice may be issued by the commissioner.
Where?
Section 35, my lord.
Section 35. Periodical so
Well,
also.
see your lordship.
Any dealer other than so also substance so required by the commissioner, notice shall be served. Yes.
So, my lord, the 35 notice, if 35 notice has been issued, then only 39 will come into operation. Because it says, my lord, in cases where notice under section 35 has been issued.
So only after notice under section 35. Section 39 will come into operation.
Yes. Now, the similar issue came up before the Division of Tripura High Court where the similar provision was there. Your Lordship, I sent it by mail. In fact, I came yesterday only. That came to know, my Lord. I sent by mail, my Lord. I think Your Lordship might have got it, my Lord, by the. This is WPC 1109.
You are
my
appearing
Lord.
for 2 and 3. Who is
2
the
and 3.
counsel on record here? Somebody is here?
Yes, my Lord. The advocacy record is there, my Lord.
Yes, yes. Yes.
1109, my Lord.
Oh, 1109. Yes.
My Lord, I will take Your Lordship to page paragraph 12, my Lord. At page 6, my Lord.
Yes, 6.
My Lord.
Page 6. Yes.
Here the court was examining, my Lord, section 27 of the Tripura VAT Act, Lordship may see section 27. Each and every dealer in relation to any tax period furnished by a registered dealer to whom notice has been issued by the commissioner under section 24 shall be subject to scrutiny for the assessment. This is parametria to, my Lord, section 39 of the Act. Now, Lordship may see para 13, my Lord. Section 29 permits self-assessment. Section so-and-so provides for, subject to the provisions of section 2, the amount of tax. Your Lordship may skip over, my Lord. This one, I take Your Lordship directly to 15, my Lord. Or I, my Lord, instead of, Lord, I will take Your Lordship directly to para 17, my Lord. At page 8, my Lord.
Page 8. Yes. Para?
Para 17, 17, my Lord.
Para?
17,
17. Yes.
my Lord. Section 27 of the TVAT Act pertains to scrutiny returns. Subsection 1 of Section 27 provides that every return in respect of a tax period furnished by the registered dealer to whom notice has been issued by the commissioner under Section 24 shall be subject to scrutiny by the assessing authority to verify the correctness of the calculation, application of correct rate of tax and interest and input tax credit claimed therein, and full payment of tax and interest payable under such period. Subsection 2 of Section 27 provides that a mistake is detected. If a mistake is detected as a result of the scrutiny, the Commissioner of Taxes shall serve a notice in the prescribed form on the dealer to make payment of the extra amount of the tax interest as per the provisions of the Act. Section 27 of the Act is thus not a provision for full assessment of the return file of the response to the notice issued under the Commissioner under subsection 2 of Section 24 of the Act. It is mainly for the purpose of verifying the correctness of the necessary returns furnished in such return, such as calculation, application of rate of interest, as well as the payment of tax and interest of such return. If any error is detected by such aspects under subsection 2 of Section 27, the Commissioner will issue a notice of recovery demanding payment of the extra tax and interest. These powers are essentially in the nature of prima facie adjustment. The provision contained in Section 27 of the Act are vastly different from the provisions of self-assessment under Section 29, provisional assessment under Section 30, and most significantly, the audit assessment 31 of the Act. The special powers can be exercised only in relation to a dealer to whom notice has been issued by the Commissioner under Section 24 of the Act. Section 24 refers to the issuance of notice only under Section 2 of the Act. Necessary, therefore, unless and until such a notice is issued in terms of Section 2 of Section 24 of the Act, the VAT authority cannot invoke the powers under Section 27 of the Act. Any other view would defeat the very scheme of the said chapter, providing for audit assessment and limitation for completing such assessment as provided under Section 33 of the Act. The respondent authority cannot be allowed to circumvent the limitation provision for completing audit assessment by permitting resort to the powers of the summary adjustments under Section 27, which are peculiar in nature, are available only in case where the notice under Section 2 of Section 24 of the Act has been issued to a dealer. In the result, the impugnated orders under Section 27 of the Act are set aside, and if demand notices consequent to so are also invalidated. Now,
Yes.
in the present case also, my lord, section 39 provides that only in cases where notice has been issued under section 34 by the commissioner. Now, in the present case, my lord, 35 by the commissioner, my lord. In the present case, no notice was issued by the commissioner under section 35 of the act. In fact, the notice which the respondents are saying in section issued in section in the year 2017 is only for the notice for assessment. There is no notice by the commissioner under section 35 of the act. Now, if no notice under section 35 of the act was issued, then section 39 will not come into operation at all. And thereby, my lord, the order which has been passed under section 39 of the act is absolutely without jurisdiction, because the mandatory preconditions for the exercise of the powers under section 39 of the act are wholly absent in the present case. Now,
What is
coming
the
to the
judgment?
second-
What is the judgment of the Kerala High Court?
my lord, Kerala High Court, I will come to directly the Supreme Court judgment, my lord. 2017-11 SCC,
2000?
7-11 SCC, my lord.
Even the citation.
The 2007-11 SCC, page 363.
Do you have a copy?
My lord, I've sent by mail, my lord.
I have not been provided, madam, that copy.
You have not been provided.
Well, that has not been sent, right?
It was sent, my lord, yesterday. In fact, I think.
You have to provide us.
My lord,
The advocate record, I think it was sent 2007-11 SCC.
2000?
7-11
7?
volume 11 SCC.
2007. 11 SCC, page
363, my lord.
363.
My lord.
What is the principle involved there?
My lord, say that where the no limitation is provided in the act, then the assessment must be completed within a reasonable period, and reasonable period is to be determined on the basis of the scheme of the act. And the court, apex court, came to the conclusion, my lord, that since 5-year limitation has been provided for assessment and for reopening of the assessment, and thereby that shall be the period for the purpose of the assessment in case where the no limitation is provided.
It's not there. Where is your citation, Mr. Mosika? Who said you are going to circulate the judgment?
As relying on Mr. Saraf, my lord. We will place 2007-11, my lord.
So that's the only issue. But in so far
My
you
lord.
are concerned, Dr. Mosika, in so far your case is concerned,
Here also there is no notice.
that's right. No. Dr. Ashok's case is that initiation has been done only after a period of 5 years.
Even in my case.
What we, no, in your case, initiation has started, a notice has been sent, and it's a continuous cause of act. This is what she argued yesterday.
My lord,
yes, your lordship.
my lord, the facts are more or less identical here, my lord. But even in my case, my lord, the assessment order has been passed. The initiation is not relevant, my lord. The impugn order, whether it is passed within 5 years or not. Because what section 57 says, my lord,
No, your lordship. It is
What should be passed within
not,
5 years?
yes, your lordship, my
Hey,
affidavit.
1 minute, madam.
1 minute, please, some patience.
57.
Section 57, my lord, the wording is, no assessment order shall be passed.
No assessment under section so and so shall be made.
So whether notice was issued or not issued, my lord, that's not relevant. Firstly, my lord, and secondly, my lord, even the notice that is envisaged under section 35 is it
So according to you, when there is no action
my lord,
or decision taken within a period of 5 years
my lord.
from the date of the assessment year,
Indian
then the entire proceeding is marked by limitation. What's your case, madam? That's the point, sum and substance.
Lordship, initially, Your Lordship, petitioner has, there is some discrepancies detected in the return filed by the petitioner, Your Lordship. Some discrepancies detected. Discrepancies regarded, because he filed the, filed his return after 20 days of the 21 days of the succeeding period, Your Lordship. Thereafter, he was asked to produce by notice date 10/5/17 to, may I read, Your Lordship? Affidavit in opposition, Your Lordship. My objection at page 11. Page 11.
But what do you say? You read section 57. No assessment shall be made after expiry of 5 years.
But Your Lordship, this case is not after assessment was made, before that, Your Lordship, because,
Before 5 years.
yes, Your Lordship, because 17
So
onward,
you have already taken a decision before 5 years, and the discrepancies were to be set right.
yes, Your Lordship, because 17 onwards, he was, assessment was made from 12 to 17, Your Lordship, and from 17 onwards, notices was forwarded to him to come and rectify his defect.
So
But
he has not come.
he has not come. Then, on the basis of record available in the office, assessment was made under section 45, Your Lordship.
45 within 5 years.
Yes, Your Lordship.
45, my lord, does not provide limitation also.
And 45 does
45,
not,
my lord, does not provide limitation.
45 does not provide limitation, Your Lordship.
That proceeding, my lord, was taken up under section 45.
My lord, kindly, once again, my lord, I'll read once again section 57, my lord.
Your Lordship, page 39.
My lord, if you want to permit me, my lord, I'm not disturbing your lordship, my lord.
Yes.
My
Yes,
lord,
yes,
if you
sir.
want to
Yes, Dr. Ashok, yes.
My lord, in section 57, the word language used is, my lord, is made. Now, the division bench of the Guwahati High Court has the occasion to interpret the provision, my lord, that of the Guwahati Act, where the same language was used, is made. And the court held, my lord, that initiation of the proceedings will not be sufficient unless and until the order is made within the 5 years, then it will cannot be said that the order has been made. The court distinguished, my lord, the
So
initiation of the
in your case, order has been made after 5 years.
my lord. In my, not my case, my lord, in my case, my lord, it was 10 years.
So what is it? After 5 years? Whether
After
5
5
years
years.
or 1 day or 10 years doesn't matter. Beyond 5 years.
My lord,
Even in my
yes,
case.
But in your case,
in my
assessment
case-
has been made within 5 years and they sought for rectification or rectification.
My
No,
lord,
no, I think-
my lord, the impugned assessment which we are challenging was done beyond 5 years of the tax period, my lord. Section 57 says, my lord, no assessment
My lord,
and so and so made after the expiry of 5 years
That's right.
from the end of the tax period. From the end of
I'm
the
sorry.
tax period, my lord. My lord, I'll indicate what are the tax periods in my case, my lord.
Yes.
Page 13, lordship will see.
Page
13, 1-3. Page 13 of my writ petition, my lord.
1-3. Yes.
My lord, at page 13, at serial number 3, lordship will see assessment period. 13/6/17, my lord.
13, 36 to
36/17, my lord. The next page, your lordship will see.
Yes.
Quarter ending 31/3/17, my lord, serial number 3. Then next page, your lordship will see serial number 4, 31/9/16. It is going back, my lord. If your lordship, I'll refer to page 21, my lord. The period is 36/15.
36.
Page 21, lordship will see. It's serial number 4, my lord, 36 to 2015.
So it's going backward.
It's going backwards, my lord. So the
One
latest,
order was passed on 30, the assessment period was 36 2017.
the last, my lord.
Ah,
The last assessment period was 30/6/2017,
ah.
and the order is passed on 9th August 23, my lord.
So they've initiated an action in August 2023.
So, my lord, the order, assessment order that has been passed is passed beyond 5 years of the tax period, my lord.
My lord, in fact, I was not aware, my lord.
What is the?
Your Lordship, but in between notices were served on him.
No. It is not a question of notices at all. It is a question of decision taken.
Decision taken
See,
after
the
in 23.
wording, suppose the wording is the initiation is within 5 years, you can continue even after 5 years. If the final decision has got to be rendered within 5 years, is the wording in section 57.
But assessment made under here in this case, Your Lordship, number 1,
Huh?
assessment was made under 45, not 57.
45.
But even that submission is not correct. Lordship, kindly see page 14, my lord. Page 14 of my writ petition, my lord.
14.
Page 14, my lord.
This is under 13. Return scrutiny is under 13.
Yes.
Scrutiny of return sheet, my lord. The heading. Then your lordship will see quarter ending 31/3/17, the return is scrutinized under section 39.
Page number 13. Page number 13.
So, my lord, they are exercising power under section 39, my lord,
Page number 14.
without giving a notice under section 35. Without notice under section 35, what my senior has submitted just now, my lord. Without commissioner's notice under section 35 and beyond the period of 5 years.
But page 13, Your Lordship, it is under page 13, annexure 2 of the writ petition, Your
Right, sir.
Lordship, it
Yes.
is 45. 45.
Serial number 6.
Serial number 6, Your Lordship.
Serial number
6.
Page number 13, serial number 6,
Six.
my lord.
13.
Page number
13,
13.
13, my lord.
13.
And serial number
Number
6.
six.
It says sections with subsections under which assessment is made.
Made under section 40.
Section 45 Meghalaya VAT Act. And return scrutinized, next page, my lord, that is under section 39.
39.
Page number 14.
So, when no limitation is prescribed, my lord, the 5 years will apply, my lord, in view of the Supreme Court judgment.
So if you see section 39, it has got to be scrutinized.
Yes.
My lord, section 45, your lordship will see section 45, if I may read, my lord. If no returns are furnished by a registered dealer in respect of any period by the prescribed date, or if the commissioner is not satisfied that the returns furnished are not correct and complete, the commissioner shall proceed in such manner. Here the order has not been passed by commissioner, my lord. The lordship will see the order is passed by assisting superintendent.
If my lord, I can clarify on this point, my lord. If my lord will come to section 26 of the Meghalaya VAT Act, my lord.
Yes, sir.
Section 26 says, my lord,
Delegation powers.
delegation of commissioner's power, my lord. It says, subject to such restrictions and conditions as may be prescribed, commissioner may, by order in writing, delegate any of his power under this act to any person appointed to assist him under subsection 1 of section 25. If my lord has a copy of the rule,
Rule 40, section 45 has not been delegated.
my lord,
Section 39.
my lord,
35.
the rule, Meghalaya Value-Added Tax Rule 2005, my lord,
You have filed your
Alright.
objection in all matters?
my lord,
You filed objection in
Send
all
a copy.
matters?
Yes.
I have filed.
In all cases? All the 3 cases?
Only in my cases, my lord, 2 and 3.
You Meghalaya value added tax rules,
Yeah, my lord will come to chapter 2.
page 2, chapter 2.
Chapter 2, my lord, here.
Well, I've sent the photocopy of the relevant part, my lord.
Yes.
Point number 5 here, my lord. While delegating the above powers by the commissioner, he shall not delegate to any officer appointed to assist him any power other than those enumerated below in respect of the sections mentioned in column 2, nor shall he delegate any power specified in column 3 to any officer below the rank specified in the corresponding entry in column 4 of the table. This is the table, my lord. My lord may kindly come to serial number 5 of the table.
Super of taxes.
Yes, 39. If any proceeding, my lord, that has been delegated to superintendent of tax, my lord, and serial number 4, section 45 is included, my lord. Proceeding under section 45, that also has been, my lord, delegated to superintendent of tax, my lord. And if my lord will come to the next page, section 56, my lord, this is not the case here. 56 also, the power is under section with the superintendent of tax at serial number.
Page number?
My lord, here, next page only, my lord, in the table.
Next page, yes.
Serial number 8, section 56.
60?
Serial number 8, my lord.
This side. Oh, 56.
The power is with the superintendent of tax, my lord. And then, my lord, if my lord will come to the next page again. Serial number 30, my lord. It's section 55. This is exclusively, my lord, it's commissioner of tax, my lord. This power under section 55 can be exercised only by the commissioner of tax, my lord. This cannot be delegated to the superintendent of tax. My lord, what has happened in this case, my lord? 59. My lord, proceedings were drawn under section 39. And then, my lord, notices also was given, my lord, if my lord will come to the next repetition, my lord, 59, which I am representing, my lord, WPC 59, my lord.
59, I am appearing, I think.
I have filed an affidavit in that case, my lord.
No, but 59, I have not made my submission.
Copy has been served.
My lord, we have served the
Yes,
copy.
yes, my lord. Now, before you make a submission of 59, let me make my submissions.
What is this 2023 ACC Online 95?
My lord, if your lordship, before my lord, your lordship gives a hearing, my lord, if I may clarify, otherwise, my lord, the confusion will be created, my lord. If your lordship so, my lord, thinks it.
Yes.
My lord, two issues are there here only, my lord.
Oh.
In item 59, my lord, we are concerned with section 39 of the Act, my lord. Now, section
39 deals with scrutiny.
My lord,
45 deals with assessment. They said for the purpose of scrutiny, notice under section 35 has been issued to scrutinize the reports in terms of 39. A decision has been rendered in terms of section 45. It appears to be the argument.
After the scrutiny, my lord, they were given the they were
please,
notice for curing of defects, my lord.
My lord, if we can show a single notice by the Commissioner of Taxes under section 35.
My lord, this power is delegated to the superintendent of tax.
35 power has not been delegated. I'm sorry. 35 power has not been delegated.
I have already shown the table, my lord.
That's you have shown 39. I'm saying 35. 35 power has not been delegated.
Which you have highlighted in your affidavit.
My lord, I have.
Everything.
I have, my lord, in my affidavit I have mentioned about delegation of power, my lord.
If I get 2 minutes, 5 minutes, if you lordship so permit, out of a valuable lordship time,
no. You have got time till 4:45.
No, I know time. I am taking, my lord, your lordship's precious judicial time, my lord. My lord, section 39 power is with the assessing authority. There is no doubt about it, my lord. It has been delegated. But section 35 power has not been delegated. It is with the Commission of Taxes only. Now, section 39
But
power
he
by
has
the assessing
produced a chart showing
My
that the
lord.
superintendent has got powers. That is the
That is
argument.
39. That is 39, my lord. 35 has not been delegated. Your lordship kindly see 35 has not been delegated.
So according to who has issued notice?
The Supreme Taxes. My lord, the
So
Supreme
according to initiation itself is bad.
is bad because the 39 power can be exercised only when the commissioner issues the notice on the section 35. If he can show a single notice by the Commissioner of Taxation on the section 35, my arguments will fall.
See, he referred to some other provision also, section 25 or 26.
Well, 36 is about the submission of the returns. It has no connection. He may show any provision of the entire book, my lord. Who can stop him?
26, you know. But is there any written communication or order that he has delegated the powers to the superintendent?
Well, that is submission of the returns, my lord.
My lord,
This is not the assessment.
See, it says, subject to the restriction and condition that we prescribed, the commissioner may, by an order in writing, delegate any of his powers under this act to any person appointed to assist him under section 1 of
If you
section
can show, my
5.
lord, if you can show that any notification by this section 35 power has been delegated, he is not making. In the petition, I have also said the 35 power has not been delegated, and there is no reply. Well, the two issues are coming up here, my lord. If your lordship may permit, my lord. I'm sorry, my lord, I'm repetition.
Is there any proceedings?
my lord,
My lord.
I need instruction whether any.
Senior Mr.
My
Ashok,
lord.
you must understand.
My lord.
See, it is not restricted only to 25. The commissioner is empowered to delegate his entire powers
Yes.
under this act.
Absolutely, no, there is no dispute whether it has been delegated.
Whether it be delegated. See, according to him,
My lord, section
there is a
35 power
delay.
has.
There is a delay. You pass orders in terms of 55. No, sorry, in terms of 57, the delay of 5 years. Beyond 5 years, you are not entitled to take any action. That is his argument.
Yes, my lord.
As far as Dr. Ashok is concerned, first of all, it is hit by delay, latches. Apart from that, the initiation itself is bad because there are no proof to show that the commissioner has delegated his powers. It should be in writing.
Now here, my submission is, I have,
My lord, if your lordship may,
I have
may
already
read,
shown.
One minute.
My
See,
lord,
one
my
by one, so we'll understand.
No, my lord,
Manage the document.
my lord, I will read, I will need some instruction in this matter. But my lord, as far as my point is, my lord, as far as my point is, my lord, when the power under section 39 has already been delegated, now entire.
Sir, we will take it that it has been delegated.
Right, my lord.
It is in terms of section 26.
26, my lord.
In terms of there should be an order in writing. The provision doesn't say anybody can act on behalf of the commissioner. It is not so. The commissioner should give it in writing.
My lord, in terms of the rule also, my lord has already seen section 39 power has already been delegated. Section 39 to the superintendent of tax. Now, when the section 39 power has already been delegated, now whatever could be possible to do under section 39, that can be exercised by the power to whom the power has been delegated, my lord.
Where is the proof? Give the proof that it has been delegated.
My lord, section 39, I have already shown the table, my lord, in the chart. In the rule, my lord.
Page number?
Chapter 2, my lord. Serial number 5.
Yes. Certain thing has got to be done in terms of the act. Rule rule-making power is different. You cannot give powers in terms of the rules when you have not done it in terms of the act.
My lord, in terms of the section 26 only, my lord, when the rule was framed, the power has already been delegated, my lord.
No, sir.
One
I'm
minute,
very-
1 minute. Subject to the provisions. Commission may not do official gazette. Subject to the provisions of the Act, made rules hereunder, the Commissioner may by notification official gazette, so on. So, the officer to whom powers the Secretary delegated shall exceed the powers and so on. Oh, these are the powers
Yes,
in terms of the rules. So,
Well,
it's
if you lost it,
instead of doing it in writing, a rule has been
My
framed,
lord.
saying that the Commissioner has got power, the Superintendent has got powers.
Yes, my lord.
Well, if you lost it, looks at rule 7, you know.
Huh? Rule?
If you lost it, rule 7, you know,
Rule 7 of? Yes.
my lord. While delegating the above powers by the commissioner,
1
he
with
shall
5,
not,
1 with 5.
my lord.
So, where is rule number 6 and 7, sir? In the rules.
In chapter 2 itself, my lord.
Yes. Where is rule number 6 and rule number 7?
This is not complete, my lord. Even my copy also, my lord.
My lord, I've given the photocopy, my lord.
Remember? Rule number 6. The officers to whom the powers may be delegated in subsection 1 of section 26 shall exercise powers subject to the provisions of the Act and rules made thereunder. And to
My
such,
lord, first of all,
as may be, this is the
first of
Act.
all,
This is the Act.
my lord, first of all, rule 3, your lordship may see, my lord.
This is
Rule
the Act.
3, my lord, as you got, your lordship got rule 3, my lord.
Oh, yes. Here you see. I don't know page number also.
Chapter 2, rule 3.
Yes, sir. Yes,
My lord,
yes.
first of all, my lord, is similar subject to the provisions of the Act and rules made thereunder. The commissioner may, by notification in the official gazette, delegate the powers to be exercised by the opposite officers under subsection 1 of section 26 of the Act, and shall by notification specify the area in which power to be exercised, so and so. So, my lord, the commissioner has been given a power to delegate the powers by notification. Now, we'll also make 4, my lord. The officers to whom the powers under section 1 or section 26 shall be delegated shall exercise the powers in respect of such persons or class of person respect of so. So they will delegate only the powers will be exercised only by the persons to whom the power has been delegated by the commissioner. Now, your lordship, kindly see me, lord. I will take your lordship to 6, my lord. The officers to whom powers may be delegated under subsection 1 of section 26 shall exercise the powers subject to the provisions of the Act and the rules made thereunder, so as to restrictions may impose the commissioner may in delegating the powers. So this is also subject to the delegation by the commissioner. Now, lordship may see 7, my lord. While delegating the above powers by the commissioner, he shall not delegate to any officer appointed to assist him any power other than the power enumerated below, in respect of the sections mentioned in the so-and-so, nor shall delegate any powers specified in column 3 to any officer below the rank of the specified in corresponding so-and-so. This is the limitation. The schedule is only limitation that the commissioner cannot delegate the powers other than whatever has been specified in the schedule. May I read again once again? While delegating the powers by the commissioner, he shall not delegate to any officer appointed to assist in the power other than those enumerated in respect of the sections mentioned in the column 2.
Yes.
Nor shall he delegate. So this is not a delegation. My lord, my learned friend is again showing the chart. This is not the delegation of the powers. This is only is that these officers can be delegated the powers. This is limitation on the delegation. There is no delegation of powers by the rules. It puts a fetus on the powers of the commissioner.
It should
that
be
he
in order,
cannot-
it should be in writing.
In
The
writing,
rules have been
delegate.
framed. Where is the order in writing to initiate action?
My lord, may kindly give us a short time, my lord, we can take some instruction in this.
Madam, when he is taking instructions, I may also place the judgment of the Supreme Court. The copy was not there, so that he can take
The
also
request of the
instructions.
respondent.
This is-
What's the matter? You would submit that in terms of rule. Meghalaya value added tax rules. Come on. The superintendent has got powers. More so in the light of section 7. And in the light of section, in terms of rule 7, on the table mentioned thereunder. And that when the powers are delegated to others, more so in the light of section 26, the superintendent has got powers to decide the issue in question. That apart, there is no delay. He would also stated that it's already filed his objection and produce relevant documents to show that the commissioner is empowered to delegate powers to superintendent who acts in the representative capacity of the commissioner and decide the issue with regard to assessment. Dr. Moshika and Dr. Ashok, senior advocates appearing for the petition, would submit that the powers cannot be delegated in terms of rules and that in terms of section 26, there should be an order in writing, which is absent in this case. The other part, in terms of section 57 of the Act, Value Added Meghalaya Value Added Tax Act, beyond 5 years, the authorities have no jurisdiction to scrutinize and assess full stop. Dr. Moshika vehemently contended that a decision has been done in terms of section 39 and that no decision has been rendered in terms of section 45. In reply, the counsel appearing with the department would submit that in terms of section 39, assessment has been done and scrutiny has been done in terms of section 39 and assessment has been made in terms of 45. Both the senior advocates appearing for the petition would submit that the entire act has got to be read in conjunction and an harmonious reading has got to be given, and that the period of limitation in section 57 needs to be applied to all the proceedings, and that when there is no initiation under section 35 by the commissioner, in the absence of delegation of powers, the proceeding itself ab initio void. So, in order to enable the parties to make further submission, post the matter during the first or second week of June.
My lord, if your lordship may also ask the,
Both of you.
Hello.
That's a summary.
If your lord-
Sir,
if your lordship may also ask the respondents to place that any order was passed under section 35 by the commissioner, because that will be very much necessary, my lord.
anyway, they will give, we
any-
have passed a detailed order. They will have to do.
My lord.
Absent
Right.
everything we have stated. Your argument is reflected. Everyone's argument is reflected.
Obliged.
My lord, I am highly obliged, my lord.
From the list, item number 1.
Yes.
Entry.
You send the papers. We will read. 1, 2, 3. Yeah. Is this?
From the list.
Item 1. First list of supplement is over. Yes.
May I please the Lord? My Lord, it's an appeal under section 260A of Income Tax Act, Lordship. Lordship, my Lord, we are aggrieved by the, my Lord, order passed by the Honorable, my Lord, IT, my Lord, on 2/1/2023, my Lord.
260 A.
Lordship. In fact, my Lord, in the original assessment order, my Lord, the return filed by the assessee, my Lord, 3 additions have been made by the, my Lord, assessing officer, my Lord, on
So it's
3
coming up for admission.
admission, Lord. Lordship, additions has been made, my Lord.
Take notice.
Your Lordship, the counsel for the respondent who is from Delhi is indisposed, Your Lordship. So paying for short date, Your Lordship.
My Lord,
That's what we asked. That's what we are saying. We are appealing only one time.
my Lord, may I humbly submit, my Lord. It's an appeal, my Lord, only after formulation of substantial question of law, my Lord. Respondent can be heard, my Lord, under section 260A, my Lord, subsection 3 and 4.
Where is the question of law?
Yes, my Lord. We have proposed, my Lord, in our, my Lord, appeal, my Lord, that is in page number, my Lord. In my appeal, my Lord, it's in, Lordship will find at page, my Lord,
In Madras High Court, there will
9,
be a substantial question of law in the grounds of appeal itself.
my Lord, because, my Lord, only after formulation,
Here you are giving it separately.
my Lord,
You know, whatever you are giving is only to assess the court. It is for court to frame.
Lordship,
Yes.
Lordship, yes, my Lord.
Where is it?
My Lord, we propose that page number 9 of the petition, my Lord.
Nine.
The appeal, page number 9, my Lord. Because, my Lord, the Honorable Tribunal, my Lord, they have admitted,
These are two questions of law.
my Lord, my Lord.
No, facts, circumstances, justification of disallowance, research, and so on. We have to consider only one. If one is answered, automatically 2 will go.
Lord,
This is our finding of fact. Suppose we don't agree with you on question number 1,
my Lord,
the issue number 2 will automatically will go
Lordship.
finding of fact. Oh, admit notice, question of law. Also has been framed. The following question of law arises in this appeal. Sir, page number 9, question number 1 alone. I mean, issue they framed. It is not substantial question of law. At the request of the respondent to file the objection. When do you want?
A short date, Your Lordship.
Monday. 20th.
Yes, Your Lordship.
So we'll file your objections.
Yes, Your Lordship.
If you don't file, what to do? We'll allow the appeal. How can you file an objection within 2 days? Tomorrow and day after tomorrow, holidays, we don't know. But anyway, you are not appealing with the department. Yeah, what's the matter? Sometime in
My Lord,
24th July.
deeply obliged.
Yes.
Item number 2.
Oh, this is the question which he has argued.
But the objection was raised with regard to maintainability, my lord, referring to section 35G of the Central Excise Act.
This is the matter, I think I dictated to you, no? Aragwan. Yes. No, the last time they came to the council was not well or something, matter was adjourned.
Before that, it was heard, my lord.
3-5, you took adjournment.
Yes, 3-5, I took adjournment, my lord. And before, on the previous date, it was heard, my lord. But mainly the objection is raised by them under section 35G, my lord.
The appeal is not maintainable.
But appeal is not maintainable because this involves a question regarding valuation, my lord. Now, my lord, if I may draw your lordship's attention to section 35G, my lord.
35?
35G, capital G.
35G, yes. I think I remember this case that we said that appeal is not maintainable.
Well,
Yes.
my lord kindly looks at section 35G, my lord.
35?
35 capital G.
Contracts. Intellectuals. Central excise, not income tax.
No, this is excise, 35G of the Central Excise Act.
Ah, yes, yes. 30?
This has been borrowed from
35
principles of the
capital G,
Service
my lord.
Tax Law,
35G.
Lordships.
Capital G.
Yes. Which page?
The omitted portion, lordship, we find at the footnote, my lord. The 35G was omitted by National Tax Tribunal Act, my lord.
Yes, appeal to the, yes.
But, so 35G, what it says, my lord, subsection 1, an appeal shall lie to the High Court from every order passed in appeal by the appellate tribunal on or after 1st day of July 2003, not being an order relating, among other things, to the determination of any question having a relation to the rate of duty of excise or to the value of goods for the purpose of assessment. So, my lord, appeal will not be maintainable if it is pertaining to the rate of duty of excise, my lord, or with regard to the value of the goods, my lord.
Sorry, entire section 35G has been repealed.
No, my lord, because of this has been repealed by National Tax Tribunal Act, my
Then
lord.
you will have to go only before the,
No, my lord, this section is still in operation.
which is in operation.
35G is still in operation because that has been stayed by, I think my friend will be able to, by Madras High
It has
Court.
been stayed.
That has been stayed, my lord.
What is this, sir?
Lordships, my learned friend is correct, my lord. What had happened, the National Tax Tribunal Act was being introduced to take away the jurisdiction of this honorable court and to create an appellate body at the national level where all issues relating to valuation, classification, etc. could be appealed to the National Tax Tribunal. But that provision, my lords, was stayed and then it was not brought into operation. So as on even today, my lords, 35G is in operation, my lords. 35G and 35L. So an appeal will lie from the order of the tribunal to your lordships if it does not involve, amongst other things, lordships. It may not be solely related to that, but if amongst other things, it relates to a question of value, then the appeal will not lie to your lordships. The appeal will lie under 35L before the Honorable Supreme Court, Lords. And in the instant case, if your lordship sees one line from the tribunal's order at para 10, the tribunal says the question relates to valuation. I need not read anything, my lords. If your lordship sees the finding of the tribunal itself at para 9, heard both sides, perused appeal records.
Para 9.
Para 10 of the impugned order.
Para 10 of the impugned order, my lords.
Which page?
Is internal page 4
Page
of the
4,
tribunal's order.
Page 4.
Page 4 of the judgment, madam.
4 of the judgment. Of the service
Page
appeal.
4 of
243 of 2012.
lordships.
Ma'am.
On page 4, yes.
Page 4, para 10. The issue to be decided in this case is whether the appellant has provided consulting engineer service as defined under 6531 of the Finance Act to their client JUD. If yes, what is the value of such service provided? So the moment there is a question relating to value of the service, my lords, that being amongst other things, the appeal will lie to the Honorable Supreme Court under 35L, my lords.
35L.
35L, my lords.
One minute. $35?
Capital L.
35L, capital L.
Capital L.
30?
35L. This was 35G, my lord. Soon thereafter, my lord. 35 capital L.
One here. Appeal to an appeal lie to the Supreme Court any judgment so and so. 35 so and so. Yes.
My lord, in my humble submission, my lord, this here the rate of service tax is not in dispute, my lord.
When you pay?
Because rate was applicable mostly in the Central Excise Act, my lord, because there are various slabs of tax rate, my lord, 5%, 8%, 10%.
Sorry, come. The present appeal has been preferred against the order of the tribunal dated 23rd June 2023 in service appeal 243 of 2012. The main contention of the respondent appeal is that, which page you refer to, sir? The order?
The order, my lords, internal page 4, para 10. My apology.
The respondent was that it provides to value of service, comma, the rate of appeal before this court is not maintainable. Both parties stated that section 35G deals with appeal to the High Court. The introduction of National Tax Tribunals Act 2005 with effect from 1/7/2003, the said appeal provision was deleted. In view of the order of the Supreme Court staying a provision, comma, the old provisions of section 35G permitting the agreed parties to prefer an appeal still exists. For the sake of convenience, the provisions of section 35G is extracted below. So also 35L. Though there is an appellate remedy available to the appellant or the agreed party, in terms of section 35G, the issue pertaining to value of service cannot be agitated before this court. The parties have got right only before the Supreme Court in terms of section 35L. In view of the same, we reject the appeal preferred by the appellant, giving liberty to the appellant to approach the apex court if so advised. The period during which the matter is pending is excluded, shall be excluded for the purpose of limitations.
Great. Dear obliged.
To extract both the provisions.
Item number 3.
So, Mr. Ramchandran, what is it? Ravi? Mr. Bharat.
Mr. Raichandani Lordships.
What's your name?
Bharat Raichandani Lordships.
Bharat. Yes.
Lordships.
Every case has got a horoscope.
Lordships. Lordships.
So we do not know when it will be over.
Absolutely.
Yes.
Dear obliged.
Yes.
Grateful. Grateful, my lord. Grateful.
My lord, I humbly pray if the matter can come up at the end of the board, my lord. The conducting counsel, Mr.
Item number
Filman
3.
Obri, is.
I think this has been argued.
Yes.
Is it not?
Yes, your lord.
Yes. Been argued. You made it ready, no? Yes.
If Lordship allow me to say something, Your Lordship.
Huh?
Allow me to make something, Your Lordship. Say something, Your Lordship.
What is that?
Lordship, their argument, their submission is that it comes within the exception, Your Lordship. Exception, Your Lordship. Lordship, in fact, going by
This is the case where
Lordship, yes.
wife was done to death.
That
Uli or Ali, somebody.
Yes, Your Lordship. That extramarital affair, Your Lordship.
Correct?
Lordship, yes.
Anyway, we'll go through the judgment part.
My lord.
Lordship, because
Whether it is coming under exception 301 or 2, we'll go through it and pass on.
Lordship, because if Lordship holds that yes, it comes within the exception, then 304 will come, Your Lordship, and Lordship will kindly see examine the nature of the injuries, Your Lordship, multiple injuries, Your Lordship. So there is a clear intention on the part of the appellant, Your Lordship, to do away with the person, Lordship.
That is the reason why we are thinking whether it should be reduced, not to send him out.
If Lordship comes to that finding that there is a clear intention on the part of the appellant to do away with the deceased, Your Lordship, then that also will come to life. Your
Anyway, that day the wife has escaped. That's all.
Lordship.
See, the wife is the property of the husband. Husband is the property of the wife.
Lordship,
Nobody can misuse.
that incident happens, Your Lordship, sometime in the month of 14 May 2002, Your Lordship. But the incident, Your Lordship, and the person who, the date of the incident in this case, Your Lordship, that is 15/5, Your Lordship. Not 14, not 14, Your Lordship, not 14/5, Your Lordship. It's 14/4, Your Lordship. Going by the cross-examination of the PW3, Your Lordship.
See, and the evidence of the wife also, she said that person was having a gun, threatening him, ran away. There are a lot of contradiction is also there. I've gone through the papers.
Lordship. Apply. Lordship. Aliyah.
Yes. Order, sir.
Lord. Deeply.
Item number 4.
Chief Postmaster General. What is the matter about, sir?
This is a transport matter, my lord. transfer of the respondent from one place to other, my lord. My lord, here we have served notice, my lord. We have received the postal certificate.
One minute.
My lord.
This communication details on the postponed indicates the post was not available. In addition to the. Oh, you want some time to dispose of it. Where is the respondent?
My lord, we have served, we have the postal certificate, my lord.
Served.
He has been served. So we'll file an affidavit, my lord, to bring on record. We just received it, my lord.
If it's received, then we'll pass orders. We'll not find the proof.
The proof is there, my lord. I have the original certificate, my lord.
You served it on the advocate.
No, my lord. We wrote to the postal department. Postal department is written back to us, my lord.
Oh, this is a letter from postal department.
Right.
Yes, yes. Name of the party is printed? No. File a proof of service.
My lord, will file.
It is represented by Dr. Mosika that the respondent has been served on 6/5/2024 and that he will file a proof of service into the registry. Full stop. Registry is directed to print the name of the party in the cost list. In case of no representation by an advocate on behalf of the respondent on so and so date, post on so and so date. Since notice has already been served, comma, proof of service deemed to have been completed. However, in order to give an opportunity to the respondent to make his representation before this court, the petitioner is permitted to serve notice
One second.
on the counsel who represent the respondent in the contempt proceeding before the tribunal. Ask somebody to serve on him.
My lord. Well, I'll do that.
To file a memo or whatever, once it's filed in the tribunal,
My lord.
post on 27th. When is it matter posted there in tribunal?
Today is 27th. Yes, 27th is okay, man. We'll serve it with them.
27th. Yes, 27/5. We can dispose of this matter.
Item number 5.
Deep.
If the matter is taken for hearing, Mr. Amit Senior Advocate.
Advocate General.
Advocate General would submit that the parties are negotiating for settlement and it is likely to materialize, and requested that the matter may be posted during the second week of June. Post on the week commencing 17th. Fix for some date, 17, 18, 19, 20. Some date. If it is not settled, we will adjourn the matter. Anyway, we are reported, if it's settled, good for you. So post it on, 1 minute. Post it on the counsel appearing for the opposite party sought a longer adjournment and hence post the matter. At the request of both the parties, the matter is posted to 27th June.
Kind, so kind. So please.
Item number 6.
Item 6.
Maybe please, Your Lordship. This is 302 matter. Your Lordship, conviction was given for life. So, in fact, basing on a document which is not exhibited.
Which is not?
Basing on a confidential statement by the High Court below. So, that was never been exhibited.
Yes. Both of you are ready.
So, little bit some more research is required, Your Lordship, because while Modi Ganga case is standing on the way, therefore, I got a decision from Madras High Court, and I am looking for further
Time.
some more accommodation.
At the request of the appellant, post the matter. And so on, so date.
Item number 7.
Develop.
May I crave your lordship's indulgence to make a mention, my lords. Well, there's one matter, your lordship's sitting in division bench, my lords. This is the matter concerning the notifications of the district council. The matter was disposed of by the division bench, giving liberty to the petitioners to file a fresh writ petition. Whereas we filed a writ petition, there is some urgency. If your lordship kindly direct listing of that matter tomorrow, my lords. I'm constrained to make a mention before your lordship.
But it has got to go to the regular bench.
Well, the regular bench is recused, my lords, in this matter.
All the three matter, all the three.
My lords, two judges have recused.
Who have recused?
Honorable Justice, thank you, Honorable Justice Dingdo have recused in the matter, my lords.
So you go before Justice Banerjee, Bhattacharjee.
Well, we can make a mention there then.
You file it in the section.
But it's already filed.
Then I'll let them, ask them to bring a note. Since 2%, I'll say that make an endorsement that it may be posted before.
Well, I'm great.
Ask them to send it.
I'm good.
From the reading list, item number 1 and 2.
One and two. Yes. Dr. Moshika.
Yes.
At your request, last time the matter got adjourned.
Now, these are two matters where, my lord, what happened? They were discharged from service in Assam Rifles, my lord, on the grounds of alcohol dependence, my lord. Alcohol consumption.
What is it? How many years of service they have rendered?
2003 till 14 years.
10 years.
14 years.
14.
2003 to 2014.
Joined in 2003, my lord, and discharged in 2017.
2017.
My lord.
So 14 years.
14 years. My lord.
Why did you give him some benefits for 14 years?
My lord, the petitioners are still in service, my lord.
There's a stay order passed, my lord.
They are still in service.
Stay order is operating.
That is right.
My lord.
But they are teachers, they are spirited teachers. See, how you can, as a teacher, how can you enter with the spirit? You are not a chemistry teacher, you know. Consumption of spirit and then entering the class will be dangerous.
My lord, in fact, in page 5 of our affidavit, my lord.
1 minute. Page
5, Lordship has WPC 221.
31/7/2018.
Sorry. Lordship has WPC 221, my lord.
I think last time I heard the matter.
Lordship has heard the matter, my lord.
What is the suggestion made by this court?
My lord, Lordship kindly comes, my lord, to affidavit in WPC 221, my lord. There are two matters.
221, yes.
221, my lord. At page 5 of my affidavit, my lord.
Yes.
Para F.
Page 5.
Page 5, my lord. Para F.
However, invalidation of medical proceeding, convening or order date so and so, the mentioned authority instead of convening and so and so, not in order procedural law, and the same was not sustainable in the eye of law. Yes.
My lord, the previous sentence, my lord, it is pertinent to mention here that the petitioner has served for 15 years and 5 months in the Assam Rifles and is entitled.
Where, sir, where?
My lord,
Page 5.
Page 5, my lord, para F.
Sir, F. Okay. Here one page, another page is there. Yeah, yes.
So, my lord, just after 6 lines, 6th line, my lord, it is pertinent to mention.
That's 5 years and 55 months in order.
Entitled for invalid pension in terms of rules also.
Oh, entitled to pension.
My lord.
Gratuity also would be paid.
My lord.
Why didn't I accept it?
My lord, here the petitioner itself is it is the second round of litigation, my lord. In the first round of litigation, my lord, if I take my lords to their own undertaking, my lord, the first writ petition was withdrawn by them. Means the impugned order was withdrawn by them with a direction that fresh medical board will be convened, whereby the petitioner will be, all the procedure will be followed. But without doing that, my lord, they have issued the impugned order, my lord. My lord, if I take.
How many Past record, back past record.
My lord, can come to my lord, page 111, my lord. Of the writ
111
petition.
of your typeset.
My lord, of my writ petition.
111. 1 minute. Yes.
My lord. Discharge of release of the service of medical ground on such and such.
So they have cancelled it.
They have cancelled, my lord.
Yes.
Pursuant to that, my lord, that fresh medical board will be convened and
They are not convinced.
not, my lord.
Then what happened?
Thereafter, my lord, suddenly the previous writ petition was the next page, my lord, 112. Pursuant to that undertaking, the writ petition was,
Order challenge instant petition. Cancel the impugned so and so. Yes.
my lord,
Order writ petition dropped, stands disposed of.
my lord.
Nothing survives in the writ petition. This is again 2018.
My lord.
Where is the medical, the board of medical officers have taken account the opinion of the specialist. What happened, sir?
My lord, thereafter suddenly, my lord, on 3rd May, page 114,
114.
the impugned order was passed.
Ah. Where is it? Where is the medical board report?
We have annexed, my lord, in my affidavit at page 27, my lord.
20?
27, page 27, annex 7.
This is dated
2017, my lord.
18.
27 February 18.
Page number 27.
Right.
This is the second one.
Second one, my lord. My lord, that order itself is on 14th March 18.
Did it connect inquiry? No inquiry.
No, my lord. My lord, these are treated as medical conditions, my lord. So medical board is constituted, and let's kindly see the opinion of medical board at page 31, my lord, of my affidavit. Page 31, serial number 7, my lord. This is the opinion. Medical category awarded. Individual is placed in low medical category S5 permanent for alcohol dependent syndrome relapse with effect from 10.
So what is your case? You are not alcoholic.
No.
What's your case?
My lord, my case is that no medical board was conducted.
That is different.
My lord, I am not the ADS, my lord. Service.
Not past card. What about this alcoholism?
No, my
You
lord.
said you take only one peg, not more than that.
Definitely no.
Ah, so that's your case.
And my lord, which my lord senior is pointing out, the medical board, the impugned order,
We do not know what is a peg, 60 ml or 180 ml. We don't know.
my lord, the impugned,
Once first drink goes, automatically second drink will know. The first drink will induce you to take a second drink.
yes, my lord. 27.
Yes.
My lord.
You are entitled to gratuity, you are entitled to pension. What is it you want now?
My lord, here the page 112, my lord. The order was, the writ petition was disposed on,
As passed on order.
my lord, on 14th March 18, my lord. On 14th date, my lord.
14 March?
18, my lord.
Ah,
My lord. And my senior is lying on the impugned order, means on the board proceeding, my lord.
which is prior to this date?
Prior to the earlier date, prior to this one.
No.
That's not correct, my lord.
Why? When was the decision taken by them to drop the proceedings?
There was a prior in point of time, my lord. It was in the September.
See, the case would have been over subsequently. But what was the date? You gone before the medical board in the month of May, correct? That's what your friend at page number 51 or 57 he said. Which page?
Page 27.
Page 27. In your typeset. Page 27. Dated 27th February. This is the second medical board.
17th February.
27th February. Sir, this is the second medical board.
Second medical board.
When was the first medical board decision which was withdrawn? Where is the order of Justice Sen?
Page 112.
112.
Mal. The first order was 28/9/17, my lord. And this was discharged, this was recalled on 25 January 18, my lord. From 112, lordship will find it.
25 January 2018, first order withdrawn.
My lord. And the first order was dated 8/9/17, my lord.
What is the date of the order?
8/9/17.
Huh?
8 September 2017. Earlier impugned order, my lord.
Yes. The second one is dated 27th February 2018.
My lord.
So what is wrong? What is wrong, sir?
My lord, the wrong is that no medical board has been.
Both the people, both are like that. Both the cases are like that.
More or less, my lord. Slightly, dates and other things are different, my lord.
Why don't you give some compensation so that we give some compensation?
Well, he'll be entitled to pension and the
Pension and gratuity and term. Why don't you give some compensation also?
because what happens, my lord,
Once you give 50,000 tomorrow, it will come to you, sir. He cannot keep quiet. He will come and buy bottles.
well, the difficulty, my lord, the alcohol consumption, it affects their mental capacity, my lord.
Which is mental health?
With the drink, my lord.
Don't worry. We are not going to reinstate him.
Because some exemplary punishment is also required, my lord, sometimes.
Some?
Exemplary punishment, because they start shooting their fellow colleague over a small fight.
I am not asking you to reinstate them. You pay some money. You are not going to give him the gun, rifle.
Because there is nothing wrong, my lord. We have completely follow the procedure, my lord. Everything has been done. He'll complete 15 years of service. He will be entitled to pension, my lord. Invalid pension, that.
Your teacher there. Teacher.
No, my lord, he is a rifleman.
Rifleman.
He is a constable. He is an armed person.
Armed person. Furthermore, you are giving it in discount. Supply alcohol in discount.
That he'll continue to get, my lord.
That we continue to get.
My lord.
That's right.
As ex-serviceman, he'll continue to get, my lord.
My lord, till date, nothing has brought on record that he was indisciplined due to alcohol dependency syndrome. Nothing was on record, my
So
lord.
when you are in a steady mind only, you will be in a position to be, when you are fully drunk and flat. What is the purpose?
My lord, we are saying that the petition is fully fit, my lord. It is not the.
Doctor finding is there. Why did you give him some compensation? Otherwise, he'll pass out.
Lordship pass out. Because for department to concede, my lord, because it did.
No. On humanitarian grounds,
If Lordship directs, my lord.
Do you have children?
Yes, my lord.
Oh, how many children you have?
2.
In the other case,
Other case, 3, my lord.
3. Are you studying?
Yes,
Which standard?
that exactly, my lord.
School.
I have to seek instructions. I have not.
See, you do one thing. See, I'm going to pass orders, not a problem. You ask them, pay the tuition fee, the 50,000 rupees, distribute it among the 3 children. Don't give it to him. Give it to the school. They will go to the education purpose.
The Lordship may direct that, my lord. If there is a welfare fund, they can pay.
Yeah, how can we do that? Once your charges are poor, we are going to accept your contention. I can't give him the relief. How can you say that you give the children? Then tomorrow it will be a bad precedent. It will not be a precedent. It will be a very bad precedent.
My lord, what happens, there is a welfare fund, my lord, which fund is contributed by the Assam rebel people only. It's a voluntary welfare fund, my lord.
Given by?
Every month, some amount is collected from all the serving people, from their salary, and a fund is maintained.
See, you want to show charity to the other man's pocket. You want to take the money of the employees and give it to him. You're saying that Assam rifles can give. What is wrong? You ascertain. See,
My lord, in other case also I tried, my lord, because they are bound by the rules, my lord. Rules do not permit. If Lordship directs that to pay from welfare fund.
so many things. What is the mediation? Suppose they come for a mediation. We'll say pay with and give equities to the matter. Ask them. Otherwise, tomorrow you'll increase the fees.
The Lordship only directs to
If
consider.
you say that you are going to increase your fees from tomorrow, you may agree to pay the money. Give after all, no, to children. I do agree that he is medically unfit. Doctor certificate is.
If Lordship, while disposing of gifts, one observation also that to consider, my lord, we will consider, my lord.
Consider?
Not to a direction, my lord. If Lordship gives a direction to just to consider on humanitarian ground, we will do that. If Lordship, just to reconsider the matter, only to that extent, we'll do that, my lord.
Post for orders the first week of June. In the meantime, I'll go through it and also.
Item number 3.
What is the matter about, sir?
My lord, here, my lord, the petitioner, she was working as a librarian in Tura Polytechnic, my lord. And this is the second round of litigation, my lord. Initially, she came before this court, my lord, when she was in service. She prayed.
Any court of charge? What is the charge?
My lord, what has happened is initially she came by way of WPC number 176 of 2021 for regularization of her service. Thereafter, my lord, what has happened? When the matter was pending, her service was terminated, my lord. And then, my lord, again, this petition was filed, my lord, challenging the termination order. Because initially, my lord, her appointment was under Regulation 3F of the MPSC rules, my lord. The order is at.
This is with regard to termination or regularization.
Yeah, termination, my lord. Her service was terminated, my lord. Without any opportunity, my lord.
So I'll also share this matter in first week of June.
Item number 4.
Please, Lordship. Lordship, this matter pertains to regularization of service of a teacher, Lordship.
Regularization of a teacher.
Regularization of the service of a teacher, Lordship, who was appointed on contractual basis, Lordship. He has been in service for more than 10 years, Lordship.
More than 10 years.
Lordship.
On what grounds you are seeking for regularization?
Lordship,
the post exists.
Lordship,
The post exists.
My lord, the petitioner was only appointed from time to time, my lord, only as a vice, my lord, during the leave vacancies, nothing else, my lord. And her service has been discontinued from 2020, my lord.
20.
Yes.
Thereafter, we filed.
All her appointments are only as vice, my lord. Vice so and so, or during the leave vacancies, nothing else, my lord.
How many days you have worked?
59 days. My lord, there several orders are there.
But then during the course of that contract basis, Lordship, I continued in the service.
But you have been appointed on a leave vacancy. Somebody would have gone on leave, maternity leave or some other leave.
Lordship, there is a recommendation also made from the inspector of school and the
Stating
recommending to regularize my service.
that is right. But what is your right? I have been continuously working.
I've been
That is not
continuously
right.
working, Lordship,
How
without
many
any,
years?
for more than 10 years, Lordship. Uninterruptedly, Lordship.
That is not
Uninterrupted.
right. No, that is not right.
Uninterrupted. And Lordship, there's a statement also in my rejoinder affidavit.
Where is it?
It's not a fact, my lord. Our appointment orders itself, my lord, will show.
Got it, no? I'll have- Because 3 o'clock a meeting is there.
My lord.
We'll hear it. This is also the same day, the first week of June. We will put up the list of dates on relevant pages, so it will be easy. Because I am coming to your association.
Yes, yes.
3 o'clock.
Clear, Lordship.